All right, let's dive right into this explainer. Today we're unpacking a really fascinating administrative law decision that perfectly highlights that classic tension between a homeowner wanting absolute transparency and a homeowners association's legal right to privacy. I mean, if you live in a community governed by an HOA, you know the balance of power can sometimes feel, well, a little murky. So, we're going to look at a real, documented case that tests the absolute limits of what a resident is actually allowed to know about the people running their neighborhood. Let's pull up our case docket for today. We'll be hitting 1. The HOA records dispute, 2. The homeowner's 2 demands, 3. The summary judgment motion, 4. The judge's final ruling, and 5. The final certification. Section 1. The HOA records dispute. Okay, so to understand this legal drama, we really need to start at the Office of Administrative Hearings in Arizona and meet our main players. On one side, we've got our petitioner, William M. Brown. He's a homeowner looking for some answers. And on the flip side, we have our respondent, the Terravita Community Association, Inc., which is the governing body of his neighborhood. So the core conflict here? Brown actually filed a formal petition claiming that Terravita totally failed to provide association records that he requested under Arizona state law, specifically A.R.S. Section 33-1805A. He filed this grievance with the Arizona Department of Fire, Building, and Life Safety, and they ended up forwarding the matter to the Office of Administrative Hearings. This officially set the stage for a really strict, by-the-book legal showdown over exactly who has the right to see what. Section 2. The homeowner's 2 demands. Now, this whole thing kicked off on May 25, 2012, when Brown sent a very direct, formal email to his HOA. And he wasn't just asking generic questions about the landscaping budget or anything like that. He came fully prepared with 2 incredibly specific, targeted demands for their internal documentation. Let's break down exactly what he was after. First up, he wanted the engagement letter, the legal services agreement, and the current fee schedule between the Terravita Community Association and their law firm, Ekmark Ekmark, L.L.C. Essentially, he wanted to see the contract and the exact financial setup between the HOA and its lawyers. Second, he demanded the meeting minutes from 2 very specific executive sessions of the Board of Directors, which allegedly took place on March 27th and April 24th, 2012. Section 3. The summary judgment motion. Right, so fast forward to September 21st, 2012. Terravita hits back, but not with the documents. They responded with a complex legal filing called a motion for summary judgment for mootness. To translate that legal jargon into plain English, the HOA basically went to the judge and said, hey, there is literally nothing left to argue about here, this case is completely pointless, and you should throw it out immediately without even bothering with a trial. And here is the exact reasoning Terravita used to back that up. They claimed that 2 of the documents Brown requested, that engagement letter and the April 24th minutes, literally do not exist. I mean, you can't hand over what isn't there, right? As for the third document, the March 27 minutes, the HOA argued that it is wholly protected from public disclosure under the plain language of Arizona law. Which brings up a really fascinating mini-mystery. Brown is convinced the HOA is stonewalling him and hiding these crucial documents, but the HOA is swearing up and down that the documents aren't even real. So how exactly does an administrative judge rule on invisible evidence? How do you settle a dispute over records that one side claims simply do not exist? Section 4. The judge's final ruling. Well, enter Administrative Law Judge Brian Brendan Tully. He reviewed the HOA's motion, read through Brown's responses, and delivered his verdict on October 4, 2012. Let's look at how he systematically dismantled Brown's requests, starting with that lawyer's contract. The judge ruled that, first of all, the HOA already stated no such letter exists, but then he takes it a step further with this incredible legal catch-22. He says that even if that engagement letter did exist, it would be heavily protected by strict attorney-client privilege. Because of that, it absolutely could not be disclosed to any third party, including a homeowner, unless the HOA explicitly waived that privilege. So existence completely aside, Brown was legally barred from ever seeing it. Now, what about those executive session minutes? The judge applied some very similar logic here based on Arizona state law. He noted that executive sessions are strictly, literally closed off to the public and non-board members. He pointed out that if Brown had actually been standing in the room when the board went into executive session, he legally would have been forced to leave. Because of that, the March 27 minutes are just not public documents available to him, period. And as for that supposed April 24th meeting, well, the HOA said it never happened, but the judge ruled that even if it had, those minutes would be similarly locked down and protected. Which brings us to the judge's ultimate conclusion, officially granting the HOA's motion to dismiss. His final statement firmly draws a boundary on exactly what a homeowner can demand. He stated, "Petitioner is not entitled to receive or view the requested records, whether they exist or not." Wow. Pretty definitive, right? Section 5, the final certification. So let's wrap up by looking at how this administrative drama officially ended on paper. The timeline moved super fast. The judge electronically sent his decision to the Department of Fire, Building and Life Safety on October 4th. Under state law, the department had until November 8th to review it and either accept, reject, or modify it. But the deadline came and went, and the department took absolutely zero action. Because no action was taken by that deadline, the process just triggered its automatic conclusion. By November 13, Director Cliff J. Vannell officially certified the judge's ruling as the final administrative decision of the department. The matter was vacated, the case file was closed, though, of course, the parties always keep the right to request a rehearing or appeal it up to the Superior Court. So what does this all mean for us? It leaves us with a really provocative final thought. This case clearly proves that certain inner workings of an HOA, especially their legal strategies and their closed-door meetings, are intensely protected by law. But if an HOA can legally shield these documents from the very residents who actually fund the community, what does that mean for the ultimate balance of power in your own neighborhood? Where exactly should we draw the line between necessary administrative privacy and a community's right to transparency? It's a fascinating question, and definitely one you might catch yourself thinking about the next time you drive past your own community clubhouse.